Proving intent to use force not required to convict for third-degree robbery. State of Ohio v. Kevin D. Tolliver. Case number 2013-0351. 2nd District Court of Appeals, Montgomery County. The state does not have to prove the intention to use or threaten to use force against another to convict an offender of third-degree robbery. The Ohio Supreme Court ruled on September 2, 2014.
The issue and the question before this court here is what mental state, if any, should be applied to the use of force element of the robbery statute prescribed in Revised Code 2911.02A3. That statute provides that no person in attempting or committing a theft offense or in fleeing immediately after the attempt or offense shall use or threaten the immediate use of force against another. The use or threaten the immediate use of force element does not specify a culpable mental state or mens rea.
The real question that I have is this idea of when we have strict liability offenses where a mens rea doesn't have to apply, or where we have a missing mens rea, and under 2901 21B, you have the language that says the default is reckless.
So is raising one's hand and making a fist force, in your view?
It could be a threat of force. It could be a threat of physical harm. Certainly threatening to punch someone in the face or punch them in the body could be interpreted as a threat to inflict physical harm.
If someone is blocking your access or retreat and you push them out of the way, is that force?
That is force, and that is precisely the force, precisely the initial force that was inflicted or used by Tolliver in this case.
The two conditions must be present for the default state of recklessness to apply to a statute which does not otherwise specify some other degree of mental culpability.
And do you not see two other degrees of culpability in this statute, purposely and knowingly?
I see that the statute does incorporate a theft offense, which is then to which are grafted other elements to create the robbery offenses, both aggravated robbery and robbery. I would submit that the culpable mental states that are contained within the discrete theft offense both A, do not apply to the additional elements, and also do not compel a conclusion that those additional elements which create the robbery offenses are strict liability.
In a 4-3 ruling, the court clarified how a 1974 law applies to robbery in Ohio. The decision reverses a ruling by the 2nd District Court of Appeals and affirms the conviction of Kevin Tolliver for robbing a Montgomery County Dollar General store. Justice Judith L. French, in the majority opinion, wrote the Ohio General Assembly defined the offense of robbery to require proof of a culpable mental state for some elements but not for others. The state does not have to prove the culpable mental state, or mens rea, of the offender for the threat or use of force element of robbery, she stated.